My name is Christian Huglo. I'm both a trial lawyer and a doctor of law. I've taught environmental law for 30 years, and I'm also the author of an annotated environmental legal code and of various specialized publications in this area. And my legal practice is specialized in this area.
In
order to answer your question, we need to distinguish between Europe as a whole and France. Chronologically, we should start with France, where industrial regulation of industrial sites dates back to the laws of 1810, 1917, and 1976. But in the 1980s, Europe took the lead by publishing some extremely significant regulations, usually as a reaction to specific events. After the famous Seveso accident on the 10th of July 1976, for example, which, if you recall, led to a dioxin leak in Milan in Italy. And Europe committed itself to the construction of a protection system for industrial sites labeled as dangerous, and which figure on a special list: risk of explosion, risk of harm for the population, which we now call the Seveso regulations. It has been modified over the years as a consequence of various mishaps and accidents. However, Europe has also established more fundamental regulations concerning industrial site management, which we call the IPPC, Integrated Pollution Prevention and Control Directive, and which covers permanent control of pollution, that is to say, regulation of waste and water management. Those are the principal directives, that is to say, the main regulations that each country has to apply to its own situation in order to be effective. This means that France is wholly responsible for the process of transposing what is known as the fifth book of the Environmental Legal Code, which covers listed sites, waste, and various other industrial risks. I should add that the French situation is particular in the sense that on the one hand, we have the Environmental Legal Code concerning pollution and other risks, and on the other hand, we have the typically French Labor Code, which exists to manage the hygiene and security risks. The health law, for example, also contains articles on security and site management. So although the regulation appears to create a unified system, in reality, it does not. I will answer essentially for France, because Europe does not have penal responsibility for the environment. It is not within their jurisdiction. Sometimes, if there is an ecological catastrophe, Europe takes an interest or makes recommendations. But as far as actual judicial process is concerned, the question of legal responsibility is always settled in each country's courts. In France, there is a three-tiered system of responsibility. First of all, there is the industrialist's criminal responsibility, because the point of your question is who takes responsibility, and the answer is the industrialist, or end user. So the first tier of responsibility is the industrialist's, in terms of his common law responsibility: grievous bodily harm, manslaughter, but also in terms of the environmental legislation. So we are talking about very serious penalties ranging from 5 years in prison to a series of not inconsiderable fines, up to and above 500,000 euros in certain cases. France also recognizes the responsibility of the legal entity, that is to say, not the natural person in charge of the company, the manager or the director, if he has not delegated responsibility. It is the company itself, not its parent company, but the actual company directly involved in management. The particularity of penal law is that the fines are 5 times higher, and the judge is authorized to take special repressive measures which go beyond fining to include site management measures, such as suspending or closing the site. The criminal law provision is thus very strong. Civil law allows for fewer possibilities. This is the case brought by third-party victims of an explosion or poisoning who ask to be awarded damages. This is resolved by an assessment of the harm done and by compensation to each individual person. This is what we call civil liability. The compensation paid out in such cases is not very significant, apart from exceptional catastrophes such as in Toulouse, or at a different level, the Mont Blanc tunnel, or events like that. In civil cases, pollution does not cost the polluters very much money in France. Non-pecuniary loss does not cost them much either. However, the worst, the most expensive, and the most dangerous type of liability for the industrialist is what is known as administrative liability, because all dereliction of duty by an industrialist can lead to an administrative reaction. This means that the industrialist is constrained by law, Article 38 of the 1977 decree, to report any incident which could cause harm to the environment, and the administration is then called upon to carry out an inspection and can, if appropriate, issue rulings calling for temporary or definite suspension of industrial activity. Thus, it is important to grasp that the administration is the most powerful body. And conversely, to answer the other part of your question, if the industrialist does not fully meet his responsibilities, be it in terms of his criminal liability, his civil liability, or in relation to the administration itself can be called into question for inadequate supervision. For example, I believe the administration was called into question in the case of the La Med petrol refinery when it exploded. The inspectors of the classified parts of the plant were summoned by the court to justify the quality of their surveillance. So, the inspectors can also be inspected. As far as criminal liability is concerned, there are two sorts. Firstly, that of the natural person of the director, the person who had the power of decision, of hiring staff, establishing safety regulations, and who had the means to exercise this power. This person also has the right to delegate his powers to another person. However, so as to avoid the division of responsibility, in 1994, the legislature introduced the notion of the liability of a legal entity into the new criminal code. In order for the liability of a legal entity, that is the company itself, to be involved, one of the employees in a specific situation has to have committed an act which in some way led him to having secondary liability. We win on all fronts, both the natural person's liability and the legal entity's liability. It is general practice in courts and state councils' offices to invoke both the natural person's liability and the legal entity's liability in cases involving the environment, accidents, health problems, for example, where asbestos risks are involved. Once the industrialist has been implicated, an investigating judge is appointed to the case, and his role is to lead the inquiry, assemble evidence, delegate certain areas of the inquiry to the police, and others to real experts to discover the real causes of the accident. The Toulouse case corresponds to this kind of procedure, and as you know, the inquiry is practically into its 5th year now. This is what we call the penal examination of a case, and it is rather tiresome in that for quite some time it takes place in the absence of the industrialist, thus causing problems for what we call the principle of audi alteram partem, which calls for the presence of the parties involved. In terms of civil liability in general, there is usually a court-ordered expert appraisal of the situation, but it has become more usual in a civil suit for the different parties to be present and to use their own experts to contest certain information. Moreover, as a result of jurisprudence, the administration now allows for a debate in the presence of the parties concerned before deciding on a sanction. This means that the administration is no longer allowed to tell an industrialist, "I'm closing you down as from tomorrow." The industrialist must now be allowed to present his argument as well as a written explanation to the administration. And the truth of the matter is that the worst thing that can happen to an industrialist is to be closed down, to have his industrial activity suspended. The fine is not the worst thing, even though it is not possible to take out special insurance. But in terms of the continuity of an industry, the most serious sanction is suspension of industrial activity.